opportunity to evaluate and examine Michaela Mason?
Yes, I did.
And how was it that you came to evaluate her?
I was initially contacted about Michaela Mason from Children's Hospital of Michigan Social Work Department. They notified me that Michaela Mason was admitted to our hospital. And then subsequently I was contacted by Sarah Mullins, and we were able to refer Michaela to be seen at our clinic at the Kids Talk Children's Advocacy Center. And that's where I performed my full evaluation.
In evaluating Michaela, did you have an opportunity to examine her medical records?
Yes, I did.
And these records involved both her pediatrician at Lighthouse Family Medicine, is that correct?
That's right.
As well as Children's Hospital and Portner Hospital, is that correct?
Yes, that's correct.
You said that you conducted a physical exam of Michaela?
Yes, I did.
When did you conduct that exam?
I conducted it on June 4th, 2015.
Did you have an opportunity in evaluating, first let me ask you this, in evaluating your records, did you confirm that Michaela was admitted to Children's Hospital on May 27th, 2015?
Yes, I did.
And is her weight documented at that time?
Yes, it is.
And what was it?
It was 8.12 kilograms, and that translates to 17 pounds and 14 ounces.
When you evaluated Michaela on June 4th, what did you note about her?
When I evaluated her, I noticed that she appeared to be very thin. When she came in, she was fully dressed, but she did appear to be very thin. She was also accompanied by her sister, and I could tell that she was almost the height of her sister, who was only 18 months old. Once we got Michaela undressed, I was able to tell that she was very emaciated. She appeared to be very thin. When I looked at her arms and legs, she had severe muscle wasting. She almost had no muscles in her arms and legs. Also, when I looked at her general body, she appeared to be very thin. She had no fat, even when looking at her buttocks. Her skin was wrinkled with no subcutaneous fat. When we obtained her weight and her height, they were significantly below the weight and the height that we would expect for a 3-year-old, or almost a 3.5-year-old, which was her age at that time. And then I did notice that her hair was very dry, her skin was also overly dry, and her abdomen was very distended.
When you say that you looked at her height and weight, do you do something to evaluate that in terms of not only her height and weight now, but how it was in comparison to what was documented in prior medical records?
Yes, so we do have growth charts that we depend on, and we have growth charts that go from birth to 36 months, and we also have other growth charts that go from 2 years till about 18 years of age. And we plot children when they present to us for our clinic visits. We plot their height, we also plot their weight, and we plot their head circumference when they are less than 3 years of age. And we compare them to other children of the same gender and of the same age, and that's how we're able to determine whether their weight and their height is normal compared to other children of the same gender and of the same age, or are they less or over than what would be expected.
Did you understand that Michaela was a premature baby?
Yes, I did.
And is that factored into how you evaluate height and weight and growth?
Prematurity is factored in. So usually when premature babies are born, we plot them on separate growth charts. And these separate growth charts go up until 40 weeks gestation, which means that when she was born, she was 35 weeks gestation. So she was approximately 5 weeks premature. We would plot her on the premature growth chart till she's about 40 weeks. So in Michaela's condition, we would plot her till she's about 5 weeks of age. And then it is expected that children who are premature, when they're babies, they grow at a rate that is much higher than normal children would. And they would eventually grow, and they would eventually keep up with normal children their age. In her case in particular, I did plot her on the normal growth chart for normal children because when she was approximately 8 months old, she was already on the 50th percentile, meaning that when she was 8 months old, she was an average weight of an average 8-month-old baby of the same gender, of the same age, and she plotted very nicely. So there was no need to plot her at this time or to correct for any prematurity.
And how much did she weigh at 8 months old?
At 8 months old, she weighed, I'm sorry, let me just double check her weight. I want to give you the correct number. When she was 8 months old, she weighed 8.3 kilos, and 8.3 kilos translates to 18 pounds and 5 ounces.
She weighed more at 8 months old than she weighed when she was admitted to Children's on May 27th. Is that correct?
Yes, that's correct.
When was her last documented medical care prior to that?
Her last documented medical care prior to being seen at the emergency department at Port Huron and then subsequently admitted was June 12, 2014.
I specifically, prior to September of 2013, so a few months before that, did you note anything unusual about her height or weight growth?
So when I look at her height and weight, and specifically her weight, because that's where I have most of the numbers, I don't have a lot of height measurements prior to that date. But when I look at at her weight prior to September 11th, 2013, and her weight at that time was 11.8 kilos, I noticed that she plotted very nicely on the growth chart. And you notice that there is a good weight gain, and she does plot very nicely on the growth chart, and she's normal for her weight.
And I'm sorry, you gave us that in kilograms. What is that in pounds?
11.8 kilograms, that's 26 pounds.
And then, in seeing her on June 4th, have you seen her since June 4th?
No, I haven't, but I was able to have our nurse call her foster care mother.
And is she continuing to receive ongoing treatment?
Yes. After we saw her at our clinic, she was supposed to follow up with occupational therapy. And when she does go to her occupational therapy appointment, she's supposed to be weighed at that time. We wanted to make sure that she's weighed very regularly to make sure that she's gaining weight at a good rate. So we were able to call her foster care mother yesterday, and she was able to give us 4 different weights that were since we saw her on June 4th till yesterday.
And what was her weight yesterday?
Her weight, her last weight that was documented to us by her foster care mother was 11 kilograms, and that's 24 pounds and 4 ounces.
When you examined her on June 4th, did you document her weight at that time?
Yes, on June 4th she was 9.3 kilograms, so that's 20 pounds and 8 ounces.
Did you ultimately form an opinion or a diagnosis based upon all of your evaluation of not only Michaela's records, but also your physical exam of her?
Yes, I did.
And what was that diagnosis?
My diagnosis initially was that Michaela was severely malnourished, that Michaela had failure to thrive, which means that after a period of weight gain, she really had lost weight and she had not gained any weight, and that she had, and my other diagnosis was neglect.
And what do you mean by neglect?
What I mean by neglect is that there were certain medical needs and there were certain environmental needs and nutritional needs that Michaela needed as a child. So as a child, she needs to be fed, she needs to be offered food, and it was apparent that she was not fed properly since 2013 till this date. When I looked at her weight, it's apparent that she was losing weight. She also had not gained weight properly since that time, and the fact that she did gain weight when she was admitted to the hospital, she gained weight when she was placed in foster care, that makes neglect a major component of my diagnosis.
And I know it perhaps doesn't pertain to your medical assessment, but could you characterize the type of degree we're talking about?
It's very severe neglect, and children, when they're not offered the proper amount of calories, it actually leads to initially not gaining weight, and then it leads to severe weight loss, like what we had seen in Michaela's case, and it leads to a lot of different delays. So, for example, in Michaela's case, when she was seen at the hospital, she was not able to walk properly without support, and now she's gradually able to walk with just proper nutrition. She was also not able to move. She was noted to be very dehydrated. So the degree of neglect and the degree of the malnourishment that she had was very severe, because she was the weight of an average 8-month-old, and she was the height of an average 18-month-old, and she was almost 3.5 years of age. So it's very severe malnourishment, and that could ultimately result in death if that were to continue.
Would you have considered her condition at the time she was transported to Children's from Fort Huron Hospital to have been life-threatening?
Yes.
You talked about the effect it had on her ability to walk. Is there also an effect this type of neglect and malnourishment would have on her intellectual ability?
Yeah, so children who are failing to thrive and children who are not offered the proper nutrition, they're noticed that they would have some developmental delays. They're also noted that once they do enroll in school that they might have certain academic difficulties. They're not able to achieve as much as other children who are offered proper nutrition. So failure to thrive or malnourishment really does have a lot of effect on her, and we've seen some of the effects in her motor skills. It's hard to assess her social skills because when she came to our clinic she was only there for a short period of time, but failure to thrive and proper nutrition, it does lead to a lot of developmental disabilities.
And you talked a little bit about height. And there's been a lot of reference throughout the course of today on height and weight. Ultimately, when you have this type of severe malnutrition, does it also affect a child's height, not only their weight?
Yes, it does. So it depends on how long the malnourishment was going on for. So usually when children are not offered the proper amount of calories, what happens is that initially they stop gaining weight at a proper rate. So their weight gain would start slowing down, and then eventually they would start losing weight. The height gets affected after the weight does. So it's only after a certain period of time or chronic or after malnourishment has been going on for a while that you start seeing the height, or you start being affected, or you start seeing the stunted growth. So in her case, she actually does have a height that's below the 5th percentile, or she has a height of an 18-month-old baby. So her height is affected, which leads us to believe that this is a more prolonged malnourishment. It's not something that just occurred over the past few months. It's something that has been going on for a while.
I don't have anything further. Thank you, Doctor.
You're welcome.
All right, Doctor, I'm going to allow some cross-examination here. First, Attorney Mike Boucher can ask you some questions on behalf of this client. That, Mr. Boucher.
Yes, thank you. Dr. Nazer, can you hear me?
Yes, I can.
Dr. Nazer, so you are the chief of the Child Protection Unit there at the Children's Hospital?
That's correct.
And and based on what I've read regarding that unit, you have staff physicians, nurses, and social workers, and you work with law enforcement regarding cases like this one, correct?
Yes, that's correct.
And part of what you do is you provide training to hospitals, medical facilities, and clinics, to physicians, probably specifically to pediatricians, to keep their eyes out for situations where these types of conditions might be existing, correct?
Yes, that's correct.
And then one of the other things that you do is you advise them as to certain protocols that they need to follow if they suspect that a failure to thrive situation is occurring. Is that true?
Yes, that's true.
As part of those protocols, if a child presents with a failure to thrive type of situation or malnutrition, you're looking at certain metrics such as the age of the child and the weight of the child, correct?
Yes, that's correct.
And the height of the child, of course, correct?
Yes.
And what you're doing is you're teaching these medical providers that they should be aware of circumstances where a child presents below the mean, correct?
It's not below the mean. It's either circumstances where the child is not gaining weight at a proper growth rate, or when the child crosses lines on their growth chart. So they could be below the mean, but as long as they're growing well, then that wouldn't really alert us.
Okay. And then are there other markers like poor hygiene and things of that nature that would that you train medical providers to be aware of?
That's right.
Okay. In this case, did Children's Hospital perform testing, blood work, lab work, relative to Michaela?
Yes, they did.
And have you examined all of that blood work and lab work?
Yes, I did.
And it is true, is it not, that there are certain organic conditions that occur with children, such as hyperthyroidism, where it's very difficult for a child to keep on weight. True?
That's true.
Have you completely ruled that out as a possibility?
That had actually been ruled out by the emergency department at Port Huron. They had tested her thyroid hormone at that time. Her thyroid hormone was not tested at Children's Hospital.
Okay, so again, that's not something that was tested by your unit, correct?
No, it wasn't tested by our unit.
And are there other Aren't there other metabolic issues, whether there be problems with the liver or respiratory issues or things of that nature, that can occur organically with a child that may impact to one degree or another the child's ability to thrive?
Yeah, so there are many medical conditions, whether they affect how the child is feeding, whether they affect how the child is absorbing the food, or whether they affect how the child is using the energy that's provided to them. And there are many medical conditions that might cause a child to not thrive well or not grow.
Or at the very minimum, perhaps contribute to the problem. Would that also be true?
That's right.
Okay. And in this case, I think as you just said, just because a child is underweight and or short in stature doesn't automatically mean that there's a neglect or abuse situation occurring, correct?
That's right. We have to consider a lot of other factors.
Okay. And you mentioned this on direct examination. You're well aware of the fact that Michaela was born premature. And the reality is this, is that with any child who's born premature, there are greater risk factors involved for that child than a child who is brought to term. Is that correct?
That's right.
Thank you, Doctor. I have nothing further.
All right, Mr. Leftley, do you have any questions to the doctor?
Yes, sir. Good afternoon, Dr. Nauser. Can you hear me?
Yes, I can.
Just a couple of questions for you. You had indicated that the one time that you had a chance to examine Michaela, that would have been on June the 4th. Is that true?
That's true.
And you reviewed records for a number of hours, but the actual exam took about 2 hours, correct?
That's correct, yeah.
You indicated in response to questions from the prosecutor that your assessment was basically that this was a neglect situation, correct?
That's correct.
And you also indicated that as part of your findings that you didn't have any further concerns that there's any kind of physical or sexual abuse going on here, correct?
That's correct.
No further questions.
Any further redirect from the people?
Yes, please, Your Honor. Just a couple questions, Dr. Nauser. The only medications that Michaela was on when she came to you on June 4th, or as part of your treatment of her, are multivitamins. Is that correct?
That's right.
So she's not in the last month been receiving any kind of treatment for a hyperthyroid disorder or anything wrong with her liver or respiration, anything like that?
No, she hasn't been receiving any treatment. The only treatment that was recommended was really multivitamins to ensure that she's receiving the appropriate amount of vitamins that she needs. She does have, when I reviewed her records in the past, she has been on albuterol or on breathing treatments, but that has not been a recent concern of ours. When she was admitted and when she was evaluated, she had no breathing difficulties. She was observed at the hospital and she did not need any other medication. So we did not prescribe any, and her weight gain has been in the absence of giving her any additional medications or anything other than just food and certain nutritional shakes.
So in response to some of Mr. Boucher's questions about other reasons why a child may not thrive, if you had a reason to believe any of that existed here, is it fair to say you would not have expected her to gain nearly 7 pounds in less than a month since she was first admitted to Fort North Hospital?
Absolutely. So if the medical reason were the only reason why she would not be gaining weight, then whether we placed her in the hospital and we observe her or whether we placed her in foster care, she would still continue to lose weight, the same as what was going on in her at her original home. But what happens is that when you place her in the hospital and when you offer her food and when she's placed in foster care, she gained weight significantly at a very high speed, and that tells us that it was undernourishment, it was more neglect rather than a medical condition when she was sent home.
Thank you, Doctor. I don't have anything further.
All right, Mr. Boucher, did you have any other questions?
No, Judge. Thank you very much.
Mr. Leftley?
No, Judge, thank you.
All right, Doctor, I want to thank you for being available here today to testify. I'm going to cut you off now and go watch your day released.
You're welcome, Your Honor. Thank you.
Bye. All right, back to the people now. We should call the additional witnesses.
No, thank you, Your Honor.
All right, to the defense, does the defense wish to call the witnesses?
Not at this time, Judge, no.
Mr. Leftley?
Judge, on behalf of Mr. Mason, no witnesses at this time.
All right, motion.
Your Honor, at this time, I move to bind over on the information as it's charged. I am seeking to amend the date as it's currently charged. It's charged May 26th. I believe based on the testimony the court's heard that this was a prolonged cessation of providing food and also water, that it is appropriate to amend the date to 2014 through May of 2015. Your Honor, as it relates
As to
to...
both defendants, I'm certain.
I'm sorry?
Both defendants.
That's correct, as to both defendants. So I am seeking that amendment at this time. Your Honor, as it relates to the law, obviously, the issue I submit that the defense is going to attempt to challenge bind over will relate to the sufficiency on state of mind evidence as it relates to all three types of crimes charged, both the murder count, the 2 counts of torture, and 2 counts of child abuse. There has been sufficient evidence demonstrating state of mind as it relates to all 3 of those counts, and I want to address them one by one. As it relates to open murder, as this court I know is well aware, we do not have to establish what degree of murder to have it bound over. Second-degree murder requires only at least a wanton or willful disregard that the natural tendency of behavior is likely to cause death or great bodily harm, and did so. In this particular case, you not only have what would support second-degree murder, but you also have what would support felony murder, which is that state of mind together with the commission of child abuse first degree and or the commission of torture. Your Honor, child abuse first degree requires a knowing, intentional causing of serious physical or mental harm. And I will cite to the court People versus Maynard. That is the case. I know it received a lot of notoriety at the time. It comes from our Supreme Court in 2004 relating to a mother who left her child, or left 2 children in a car in extreme heat and ultimately caused their death. The court found that it is sufficient, and it is necessary to show that the defendant intended to cause serious physical or mental harm to the children, and that she knew that by leaving them in the car that would result. Your Honor, additionally, in this case, I would also cite 2 unpublished opinions that were provided to the court as well as to the defense. In particular, People versus Forum, a 2013 case, the court acknowledged that because the legislature did not require an act under the child abuse first degree statute, that it can be committed by an omission. And in this case, they reference such as failing to prevent harm to a child if the defendant intended to cause serious physical harm or had known that physical harm to the child would be caused. People versus Portellos found that the failure to call for medical assistance with the knowledge that serious harm would result was sufficient to satisfy the requirements of the first abuse statute, or first degree child abuse statute. I'm also citing to the court People versus Gardner, which indicates that in this particular case, failure to provide food or nourishment supports child abuse first degree, again, if knowing or intentionally causing serious physical harm. Also notable from the Gardner case is the court's finding that it would also support intent to cause cruel or extreme physical, mental pain and suffering, which is the requisite mental state for torture. The court found that in that circumstance where this was a 4-year-old who was severely malnourished, and it was apparent from his weight loss and small appearance, the defendant's ignoring the rapidly deteriorating condition was sufficient, as well as, and in this case there was a co-defendant involved in physical abuse, but the court found regardless of the fact that there was physical abuse by another defendant, this defendant's own conduct of intentionally failing to provide food and water to the extent that that child became severely malnourished and eventually died supports that jury's finding the defendant shared the same intent to cause cruel or extreme physical, mental pain and suffering. Your Honor, in this case, I would submit you have information that this child was turned over to the custody of the defendants in August of 2013. And from the records, it's apparent there's a very marked difference in their health and well-being from that point forward. The medical records show that their weight was fine prior to that point. Mackenzie went from 2 years ago being approximately 29 pounds or 28 pounds to 25 pounds. Michaela, more remarkably so, I would submit, was 26 pounds in September of 2013, right within a month of being turned over to the defendants. And then just a few months later, in June of 2014, approximately 9 months later, she's 19 and a half pounds, and then she's 17 pounds at the time of this incident. That degradation of both of their health and well-being is demonstrative that this was not simply a failure to provide basic needs or failure to feed or to provide drink. I think that this demonstrates a purposeful and knowing behavior on the part of these two defendants for what was an extensive period of time. The fact that they no longer received any medical treatment after, in Michaela's case, June of 2014, and in Mackenzie's case, February of 2014, despite the recommendations for follow-up and despite the fact that they expected to have follow-up with their physician, demonstrates an effort to hide this neglect and hide this failure to provide, as I would indicate, I don't believe this is simply a failure to provide food and nourishment and water. This was actively withholding. Towards that end, you also have the statement that Ethan made, and we got into that a little bit about what that is admissible for. It's admissible to show Ethan, the 10-year-old, his state of mind. When Michaela is asking for water, and she's provided water by the police officers on scene, Ethan interjects and makes a statement she's not allowed to have that. And I would submit that that is demonstrative, again, of the fact that this was not only just, we forgot to give her water, but there was a purposeful withholding. These children were not allowed to have the food and water that was readily available to the other two children in the home, and it's apparent from their physical appearance that disparate treatment is also indicative that this was purposeful and intentional behavior. Add to that, Your Honor, the failure to seek assistance that is demonstrated from the facts in this case, where you have, as Dr. Spitz has indicated, a delay from the time that Mackenzie would have died in this case until the time that 911 is called. There's a significant period of time where, at the very least, Mackenzie was not provided medical assistance contemporaneous to the time that she went into whatever sort of distress she went into that day. So there is a failure to provide medical assistance, something that's also referenced in those cases. Your Honor, taking all of that together, it is sufficient to demonstrate that this was purposeful behavior on the part of these defendants. They knew the harm that this posed to these girls' health because they were told by medical professionals, as has been documented for the court. Their failure to seek medical attention for them demonstrates an intent to commit the harm that in fact was committed in this case. The death that was caused to Mackenzie and the serious injury that Michaela suffered, the life-threatening status she found herself in at the time that police responded to her home. For that reason, Your Honor, I'm asking for bind over on all of the counts as contained in the information.
Thank you, Judge. Judge, I think that the two important witnesses in this case thus far have been Dr. Spitz and Dr. Nazar. Dr. Spitz hypothesizes, and that's his job, to provide an opinion based on what he's seeing. But he's doing it with incomplete information. His report's not even done yet. He's waiting for additional information. He's waiting for additional lab tests so that he can make an appropriate assessment and sign a report to tell us what his thoughts are. I know that Dr. Spitz talked about malnutrition and dehydration. We know that he testified about bilateral pneumonia, and we know that when one has that type of ailment, dehydration is a natural component to that. We know that Dr. Spitz testified about the fact that malnutrition can occur over a long period of time. And we know that there are at least the possibility of other organic factors. The issues regarding the liver testing, which he's waiting for, and those impacts on metabolism, the child's ability to process nutrients. In this case, Judge, I don't think that there's any evidence whatsoever, certainly of first-degree murder. I know that it's an open murder charge. I don't believe that there's any evidence of second-degree murder in this case, and Ms. Armstrong is right. I think that you have to look at this question of what these two defendants knew. Ms. Armstrong's position is they knew. My position is that there's no evidence showing what it is that they knew under the circumstances. With regard to the child abuse charge, again, they have to demonstrate that my client knowingly and intentionally abused these children. I don't think that there's any of that, even in evidence, even if the court views the evidence most favorable to the prosecution. And with the torture charge, there has to be some proof that the defendants used force or threat of force, and it resulted in great bodily harm, and again, simply not present. That evidence simply isn't present in this case, and I'm going to ask the court to rule based on the absence of those factors.
Judge, certainly I would join in the comments that Mr. Boucher added. I would focus the court's attention, I guess first of all, as it relates to counts 4 and 5, the child abuse first counts. As Mr. Boucher indicated, we have to have some evidence presented to Your Honor that that there was some knowing, intentional physical or mental harm was caused by my client. If the court contrasts that with the child abuse second statute, that's very clear and seems to be directly on point with the situation that we have here. That talks about a willful failure to provide food or nutrients. That's exactly what we have here. If the court looks at the testimony from Dr. Spitz and from Dr. Bowser, they both basically have the same basic conclusion. It's just basically it's a neglect situation, a failure to act. Dr. Bowser said, I have no concern if there's direct physical abuse going on here. Again, her diagnosis of neglect, same thing that Dr. Spitz said. And so if we have a situation here where we're talking about failure to provide food or water, that should be a child abuse second, and I'm asking the court to bind counts 4 and 5 over on child abuse second as opposed to child abuse first. If the court agrees with that argument, you can't. I guess my position is you can't bind over on open murder, because if it's not child abuse first, it can't be felony murder. And at most, the court can bind over on a second-degree murder charge. Nothing further, Judge.
Great, thank you. Prosecutor.
Just by way of brief response, the bind over would have to be. There is no designation of degree at this point in time, so it would have to be on open murder. I would submit again, neglect is not a legal term as used by the physicians who testified today. It is a medical term for their purposes. What we're talking about, as in the Gardner case, where the defendant knowingly and intentionally caused serious physical harm to the victim by intentionally failing to provide food and nourishment necessary for the victim's well-being, that was precisely what supported child abuse first degree and torture in that case, and it supported it in this case as well. Your Honor, this child particularly, both of these children, the evidence relating to both of these children is also demonstrative of the intent, the state of mind that these defendants had, the lack of accident, the lack of mistake, that would only be the basis to find, perhaps, that they did not commit these offenses. The fact that Michaela wasted away, she was literally dying in front of them to the point that Detective Frisbee can't pick her up without her saying how. She's falling down because she can't, as Dr. Nasser said, she can't even walk. So it's readily apparent how diminished this child was, at the very least as apparent to everybody else around them, within minutes of seeing her. Mackenzie, what happened to Mackenzie is obviously self-evident. The fact that she died as a result. These children were dying in front of these defendants, and they did absolutely nothing, while they are taking adequate and appropriate care of the other two children. That is demonstrative of intent and purposeful behavior. And for that reason, Your Honor, I'm asking the court to bind over as instructed.
Thank you. With regards to the facts, the court has heard the testimony today. For purposes of the record, attorneys understand the standard here is probable cause. The prosecutor should probable cause to the crime is committed, probable cause to the defendants committed that crime. The evidence that this court reviews is that by most favorable people for purposes of bind over. It's in this court's opinion based upon all of the testimony, and also giving it the weight that I feel it deserves as I sit here and listen to it and have to wade through it. I find it difficult to understand how these defendants didn't have the intent to do this. And so with regards to this court does find that there is probable cause in all of the counts and is binding both of these defendants over to a circuit court bond that was previously set by me as continued.
Thanks, Ron.
You're welcome. People, if you want to put your exhibits back for reasons.
All rise. You may be seated.
Hold on, we're going to have a second. Oh,
Thank you very much.